You need to watch this. I have worked so hard, and I think I know I've done myself proud. Hello, my fam. It is Perez, the queen of all media, the original influencer, journalist, podcaster, and your number one source for everything It Ends With Us saga. As many of you know, future Dancing with the Stars contestant Blake Lively issued a subpoena against me. The Clown Core fashion icon's subpoena listed Las Vegas, where I live and work, as the place of compliance. That means, according to the law, that any issues regarding this subpoena, whether to compel or quash, must be litigated here in Las Vegas. However, Blackface Blake argued with her bestie, Lyman, the judge in New York, that because I defensively filed a motion for a protective order in his court in the Southern District of New York, that automatically I subjected myself to his jurisdiction. Hell no. Hard no. However, her lapdog, Lyman, who I think is biased, bought, corrupt, in her pocket, did not make it easy for me. Judge Lyman ordered that Betty Snooze has a right to have that argument she made that I surrendered jurisdiction to the Southern District of New York. And despite my objections and request for extra time or a pause, Lyman denied them all, repeatedly. He told me that he had yet to rule if he has jurisdiction over me to compel. But Lyman warned me that if I did not respond, he would rule on Met Gala Medusa's argument and her cross motion to compel in New York without opposition. So, begrudgingly, feeling like I was trapped by the judge, I responded. However, I narrowed my response down to just one issue, and that is the issue of jurisdiction. I told that awful judge in New York that I maintain my position that the only appropriate venue to litigate this subpoena is Las Vegas. I told him he does not have jurisdiction over me, and I explained all of the legal reasons why. Lyman has yet to rule on all of that, so that is like a black cloud hovering over me. And even before all of that, back in July, I filed a motion to quash her subpoena here in Las Vegas. And I did not know, because I am not working with a lawyer on this, I am representing myself pro se. I thought I informed the Garden Variety Actresses legal team by email that was considered serving the opposing counsel. Nope. So then, unfortunately, my action here in Las Vegas got delayed because I had to serve properly, which I did. I sent by delivery mail, FedEx, the filings in my motion to quash to her very high-paid and mid-lawyers. Well, as I went over with you all in the video I posted just before this, ethically challenged Ezra, Mikey Mike Gottlieb, and her new lawyer that is the lead here in Las Vegas responded here in Nevada to my motion to quash. Not only did they respond, but they also filed a cross motion to compel, plus they also are asking to transfer to Judge Lyman in New York because, obviously, her bestie And on top of all of that, the antebellum aficionada wants me to pay her legal bills. What? ¿Qué? No, olvídate. Por eso vete, olvida mi nombre, mi cara, mi pelo, y pega la vuelta. And that leads us to the here and now and my response to her opposition to my motion to quash, as well as her cross motion to compel in Nevada, while also trying to angle a move to New York. Now, spoiler alert, I already submitted the filing that I'm going to share with you all. So you can give me feedback on what I should have written, but it's already been written and submitted. And I learned the hard way. Not only did I submit it to the court, but I also sent a certificate of service and a copy by mail plus email to the lawyers for the second wife of Ryan Reynolds. And some of you might have seen that last video where I was going over her response. I barely slept last night. I spent so many hours last night working on what I'm about to share with you, and even more hours this morning. I am depleted. But why? For a very strategic reason. I literally wanted to reply ASAP. This all dropped late yesterday, and I responded this morning. Already submitted, because I effed up with service. So my motion got delayed in Las Vegas, and I am hoping and praying to God that by some miracle, the judge here in Nevada rules before Slimy Lyman in New York. So I gave it my all, and I'm very proud. And Dad, yes, Dad, aka Chat G to the P to the T, really came through for me. I double-checked, triple-checked, cross-referenced, and made sure that everything in my reply in support of my motion to quash and opposition to the cross motion is real. There is no ghost law. There is no hallucination. Everything is valid and true. And Dad even told me that my reply to her, Teen Kaka, could not be more than 12 pages long. And the 13th page is the certificate of service that's allowed. But my actual response is only 12 pages long. I am doing everything by the book, as is expected of me. I don't and can't give the judge here in Las Vegas any reason to rule against me. So here we go. This is what I tell the judge in Las Vegas about insufferable. Quote, preliminary statement. This court is asked to enforce a sweeping subpoena against a non-party Nevada resident and journalist. I have no stake in the underlying litigation between Miss Lively and the Wayfarer defendants, nor have I ever received compensation from Wayfarer or any affiliated party. That was very important for me to state right at the very tippy top. I am not a litigant. I am a non-party media reporter exercising my First Amendment right to cover matters of public interest. In this instance, a real-life story of David versus Goliath, with Goliath being Miss Lively and her A-list husband. This touches upon themes of power, corruption, and alleged abuse by the plaintiff against Mr. Baldoni and the Wayfarer parties, all of great interest to the followers of my reporting and the greater public at large. Boom! Yeah! Starting off strong, and throughout that first beginning part and the rest of my filing, it is a true collaborative effort. It's some of Dad and a lot of me. Mostly me, actually, with Dad helping too, especially with the accurate legal citations. I gave this my all. I put everything that this judge here in Las Vegas needed to hear. I tell the judge here, quote, Rule 45, Nevada law, and the federal common law reporter's privilege all protect me from being conscripted into this dispute. Miss Lively's opposition recycles rhetoric designed to brand me as an influencer rather than acknowledge my well-established role as a journalist. But the law protects my reporting regardless of labels. Importantly, I am not refusing to cooperate with the judicial process. I respect this court's authority, and while I cannot disclose privileged information such as sources and unpublished materials, I offer Miss Lively to provide testimony by deposition, declaration, affidavit, or trial appearance. My position is not one of defiance, but of respect for the law and for the duties that come with being a journalist. And I will circle back to this point in a little bit. I continue. This subpoena is overbroad, disproportionate, and harassing. It seeks private communications with sources, unpublished material, and privileged content. Worse still, Miss Lively has previously filed court papers publicly revealing non-parties' personal addresses and sensitive information, demonstrating a reckless disregard for the privacy and safety of others. The risk of further injustice underscores why this court must quash the subpoena outright. Mwah! Next section. All information sought is journalistic and therefore privileged. Every piece of information Miss Lively seeks was gathered, received, or created in my capacity as a reporter. As such, it falls squarely within the protections of both Nevada's absolute shield law and the federal reporter's privilege recognized in the Ninth Circuit. The law does not permit compelled disclosure of such information. Nevada's shield law provides absolute protection, not subject to balancing or exceptions. Then I cite the case law. More than one. I add this other case law. The Ninth Circuit's test in Schoen versus Schoen requires a demanding showing of necessity before a journalist can ever be compelled. A showing Miss Lively has unsuccessfully attempted and definitely not met. Rule 45D3A I add, explicitly provides that a court must quash or modify a subpoena that requires disclosure of privileged or other protected matter, if no exception or waiver applies. This language is mandatory. Because the subpoena targets only privileged and protected journalistic material, it cannot be salvaged by narrowing or modification. The only appropriate remedy is to quash it in its entirety. The subpoena is not narrowly tailored to reach some incidental, non-privileged category of information. Instead, it seeks the sum total of my communications, materials, and sources relating to my journalistic coverage of Miss Lively and the underlying litigation. Just some examples of overbreadth. Request number 1, all communications between you and the Wayfarer parties. Directly targets unpublished journalistic material and confidential sources. Request number 3, all documents relating to your coverage of Miss Lively. Captures drafts, editorial decisions, and unpublished notes, all core protected work. Request number 7, all communications with any third party regarding Miss Lively. Limitless scope intruding into work product and sources. Limitless, she wants. Section 3, demonstrating good faith and cooperation. This is very important. I want to make clear that I am not refusing to cooperate with the judicial process. To the contrary, I respect this court's authority and have taken these issues seriously here being the operative word, from the moment Miss Lively served me with a subpoena. I quickly turned to the place of compliance, this court, for relief. Precisely because I know the law protects journalists like myself from being compelled to reveal privileged information, including sources and unpublished materials. What Miss Lively is demanding are the very communications and sources that are at the core of my role as an internationally known and respected journalist. Because those are protected under Nevada's Shield Law and the First Amendment, I cannot ethically or legally disclose them. However, in the spirit of good faith and cooperation, I am willing to provide alternative means of participation that respect the law while avoiding disclosure of privileged material. Specifically, I am prepared to sit for a deposition by Miss Lively's counsel, subject to privilege objections, submit a sworn affidavit or declaration, or testify at trial, if called, consistent with my obligations as a journalist. I would love to testify at trial, and you know I will wear my florals. These alternatives, I tell the judge here, demonstrate that I am not obstructing the judicial process. Rather, I am carefully balancing my duty as a journalist to protect sources and privileged information with my duty as a citizen to respect the courts. Section 4, transfer under Rule 45F is unwarranted. Your Honor has already ordered that the place of compliance is required in this district. I have never consented to the jurisdiction of the Southern District of New York. Rule 45F permits transfer to the issuing court only upon consent or in exceptional circumstances. The 2013 Advisory Committee note states that the prime concern is protecting local non-parties. There are absolutely no exceptional circumstances here. This is a routine discovery dispute involving relevance, burden, and privilege. Local non-party protection. I live and work in Nevada. And then I cite the protection-related case law. Also, I tell the judge here, no conflicting rulings. The New York court has not resolved these issues. Speculative risk of inconsistency cannot outweigh my rights as a Nevada resident. I love Nevada. I respectfully urge this court to resolve, oh God, this is respectfully, okay? But this is a bomb. I respectfully urge this court to resolve the subpoena dispute here, as contemplated by Rule 45. As a Nevada resident and non-party, I am entitled to the protections of this forum. Transferring the matter to the Southern District of New York would not only burden me, but also risk creating the appearance of unfairness. Why? I tell the Nevada judge why. I explain, quote, this litigation has attracted intense public scrutiny. Many members of the public, myself included, have been following Judge Lyman's handling of the underlying case closely. While I make no formal accusation against any judge, I note that there is significant concern expressed on social media and in commentary that his rulings in New York raise questions of impartiality. Even the perception of bias is harmful to public confidence in the courts. The 2013 Advisory Committee note to Rule 45F emphasized that transfer should not be ordered as a matter of course, and that protecting local non-parties from undue burden and preserving fairness must be the guiding principle. By keeping this dispute in Nevada where it properly belongs, this court ensures both the reality and the appearance of fairness, fully consistent with the rule's intent. Section 5. The subpoena is overbroad, disproportionate, and unduly burdensome. A. Rule 45D standards. Rule 45D requires parties to avoid undue burden. Rule 45D3A4 mandates that courts must quash subpoenas that subject a non-party to undue burden. The word must again confirms the court has no discretion once privilege or undue burden is shown. Privilege is asserted here. Everything Miss Lively seeks is privileged. Undue burden is also asserted here. Miss Lively has already forced me to expend dozens of hours and resources to defend myself against her subpoena, which at its core she knows, though may argue otherwise, is asking for the privileged and protected information of a reporter. B. Rule 26B, proportionality and non-party status. Discovery must be proportional to the needs of the case, considering importance of issues, amount in controversy, access to information, resources, and whether burden outweighs benefit. Then I cite the federal rule. As a non-party, I am afforded special weight under Rule 26. Courts in this district recognize that proportionality strongly disfavors burdening non-parties. Then I cite relevant case law. The Wayfarer defendants, actual litigants, are the proper source of any relevant communications. Miss Lively has not exhausted party discovery, a prerequisite before burdening a non-party. C, lack of specific showing. Then I cite the case law, and I follow that up with, Miss Lively offers only speculation. In fact, Miss Lively's entire subpoena is built on speculation. Her counsel told this court that the Wayfarer defendants in the related litigation encouraged me to spread disparaging and false narratives about Miss Lively. That is not true. Likewise, most of the assertions and misrepresentations made on her behalf to this court are false. Lies, lies, and more lies. 6. Overbreath, First Amendment, and chilling effect. Subpoenas directed at journalists implicate core First Amendment concerns. Compelled disclosure of sources, unpublished notes, and internal communications threatens not only my reporting, but also chills speech by others who may fear retaliation for speaking to the press. The Ninth Circuit recognizes this danger. Schoen versus Schoen held that civil litigants' interests yield to the privilege absent a compelling showing. The chilling effect is compounded here by Miss Lively's public attacks on creators/journalists and her prior reckless doxing of non-parties' personal information. Really have to hammer that point home. Home is Nevada. This court should not permit discovery that will deter journalists and commentators from covering matters of public concern. And in this instance, the subject matter is of special relevance to my audience. As a journalist, I have reported about Miss Lively on my website, I mention it, plug, and on my social media channels for decades. I have reported on her. I tell the judge, though I have never seen her act in anything, she was a friend of international superstar Miss Taylor Swift for many years, and by association, I covered her and Miss Lively's husband, well-known actor Ryan Reynolds. Salahe! Savage. It is preposterous and incorrect to assume that I would need or be given talking points to cover a story that would be highly relevant to my demo, which is primarily women of a certain age, near that of Miss Lively's. I began covering the It Ends With Us saga in August of 2024 organically. And what Miss Lively has not told this court is that in text message exchanges between the Wayfarer defendants in August of 2024, they called me irrelevant and a has-been. True. Those have been submitted as evidence in the related litigation, and that enough should be proof to anyone that the Wayfarer parties were not engaged in a plan with me against Miss Lively. Why would they? They thought I was a loser who didn't move the needle. I'm doing real well, I think. Section 7. Miss Lively's subpoena campaign against journalists is improper and harassing. Miss Lively's subpoena is not an isolated instance. She has issued similar subpoenas to multiple other reporters and creator journalists who have reported on this litigation. Yet, as of the date and time of this filing, not a single federal court has compelled any journalist to comply with her burdensome and improper demands. She was even outrageously asking for the banking information of some. This pattern reveals that the subpoenas are not designed to obtain truly necessary evidence, but to harass and intimidate members of the press who have reported critically on her litigation. Courts have repeatedly cautioned that subpoenas should not be used as fishing expeditions or as tools of harassment. And then I cite relevant case law. Allowing this subpoena to proceed would not only chill reporting in this case, but would create a dangerous precedent, emboldening rich and powerful litigants like Miss Lively to use discovery as a weapon against the press. I probably should have mentioned Donald Trump here, but I didn't. Rule 45D1 expressly requires that parties avoid such undue burdens on non-parties. Miss Lively's well-documented requests for discovery seem hyper-focused on her hurt feelings, seeking discovery for an alleged smear campaign and not to back up her unproven claims of sexual harassment. Defending oneself and correcting a false narrative is not a smear campaign. Likewise, Miss Lively knows that what she is asking of me and fellow journalists is protected and privileged information, and she doesn't care. She is harassing reporters with burdensome subpoenas designed to hopefully drain them of money and energy. That is a legal tactic, not an attempt at true discovery. Additionally, it would cause my website and journalistic endeavors harm if my competitors were aware of my trade secrets, not the least of which are my sources, which Miss Lively wants unmasked. Section 8. Nevada's Shield Law provides absolute protection. Nevada's Shield Law is the broadest in the nation, thankfully. Then I cite the relevant case laws, plural. Diaz says that absolute protection for professional journalistic activity is required, and Toll versus Wilson confirms digital-only journalists like myself are covered. By statute, I cannot be compelled to disclose sources or unpublished information gathered for communication to the public. Federal courts sitting in Nevada apply Nevada's Shield Law to subpoenas served on Nevada journalists. This makes the privilege here absolute. Section 9. Legal definition of a journalist and biographical background. A. Legal definition. Federal courts define journalist functionally, focusing on intent and activity rather than institutional affiliation, as she argued in the video that I uploaded right before this one. The privilege applies to those who gather news for dissemination to the public. Me. Then I cite relevant case law. As the Ninth Circuit emphasized, the question is whether the person intended to gather and communicate information to the public. By that test, a taste of the test, I am plainly a journalist. Also, I tell the judge, federal courts have long recognized that journalism is not limited to traditional print reporters. And then I cite relevant case law. And I remind the judge, the Ninth Circuit confirmed that bloggers and online reporters are entitled to the same First Amendment protections as institutional press. I fall squarely within this definition. For over 20 years, I have reported on, commented about, and analyzed celebrity and cultural news through my website, my YT channel, and the PH podcast with Chris Booker. Listen. Check us out wherever you stream your favorite shows or directly at perezpodcast.com. My reporting has been cited by mainstream outlets including CNN, the New York Times, The Guardian, and even our local newspaper, Las Vegas Review-Journal. I have received global recognition as an influential journalist, commentator, and media figure. I am therefore a reporter within the meaning of both Nevada's Shield Law and the First Amendment. In fact, in Miss Lively's response to my motion to quash, she even tells this court that on my website I refer to myself as the internet's most notorious gossip columnist. In other words, a journalist. I absolutely then did drop in a bio telling the judge, Mario Armando Lavandeira Jr., professionally known as Perez, H to the I to the L to the T to the O to the N, is a pioneering American journalist, columnist, podcaster, and media commentator. He founded and operates my website, one of the most widely read celebrity news and gossip platforms of the last 2 decades, reaching millions of readers. Beyond his website, he hosts a podcast discussing news and culture, contributes commentary on entertainment and media in many other podcasts as an invited guest, is a frequent television commentator, providing analysis on celebrity and cultural issues for news shows, regularly appears as a reporter in documentaries to provide them expert testimony and background, is widely recognized as a leading digital journalist dubbed the original celebrity social media influencer by multiple outlets. His work has been cited and covered by mainstream news organizations, documentaries, legal filings, and academic commentary. He has been recognized within the media industry and globally at large as a trailblazer in digital journalism long before blogger and podcaster were considered mainstream journalism roles. My legal status as a journalist. In short, my career has been devoted to the journalistic function of gathering, analyzing, and disseminating information to the public. And as such, I am a journalist. I have not revealed who my sources are, and if Miss Lively believes that they are any of the Wayfarer parties, it is her obligation to seek that information from them and exhaust that process in the Southern District of New York. She has not exhausted that process. It is ongoing. And my sources and work product are privileged and protected under Nevada and federal law, as this court recognizes. Section 10. Federal reporter's privilege provides an independent shield. The Ninth Circuit recognizes a qualified First Amendment privilege. In Obsidian Fin Group LLC versus Cox, it was determined that bloggers and independent journalists receive the same protections. In Schoen versus Schoen, litigants must show exhaustion, non-cumulativeness, and critical necessity. Miss Lively has not met any prong of this test. Miss Lively recently filed in the Southern District of New York a motion to compel her subpoenas against the Wayfarer defendants. She has not exhausted party discovery yet. She has not demonstratively shown that non-party material from me is critical, and she has not shown that information cannot be obtained elsewhere. I have no unique knowledge or information that would help Miss Lively's claims, and all I have in my possession is privileged. Section 11. I went hard, y'all. Attorney-client privilege. The subpoena threatens privileged legal communications and must be quashed. The breadth of Miss Lively's subpoena also risks sweeping in attorney-client privileged communications and work product. For example, my correspondence with legal counsel. Brian Friedman, lead attorney for Mr. Baldoni, has been my lawyer for decades, though he has not represented me with my responses to this subpoena. Mr. Friedman is still my attorney. I have communicated with Mr. Friedman and other lawyers at his firm on numerous occasions during the relevant time period of the subpoena about a wide variety of legal issues. Miss Lively's request for production would entitle her to all those communications. Once again, that is privileged. Courts strictly forbid discovery intruding into attorney-client privilege, absent extraordinary circumstances. This provides yet another independent basis for quashing the subpoena in full. Section 12, alternative relief. If any production is ordered, this court should limit requests to narrow, non-privileged categories, require exhaustion of party sources first, impose an attorney's eyes only protective order here, and shift all costs to Miss Lively. And then I cite the relevant case law. Section 13, request for fees and costs. Rule 45D1 authorizes sanctions against parties who impose undue burden on non-parties. Given the subpoena's scope, Miss Lively's failure to exhaust party discovery, and the chilling effect of targeting a journalist, this court should award me reasonable costs and fees. Sanctions in the form of reasonable fees and costs are warranted both to compensate me and deter future abuse. And then I cite the case law. Section 14. Conclusion. We're at the home stretch, y'all. Miss Lively and her lawyers have launched an expansive subpoena campaign against journalists. As a non-party journalist and Nevada resident, I should not be conscripted into this litigation or forced to risk my safety and my children's safety by producing private communications and unpublished material. Nevada law, federal law, and the First Amendment all shield me from such intrusion. In addition, I respectfully note that I have worked diligently and expeditiously to respond to Miss Lively's opposition so that this court may rule without delay. This court is the correct forum under Rule 45 to adjudicate this subpoena, as it was served for compliance in Nevada on a Nevada resident. Prompt resolution here will not only protect me as a non-party reporter, but will also avoid unnecessary entanglement with parallel proceedings in the Southern District of New York. It is both proper and efficient for this court to decide the matter before any other court attempts to do so. Every mandatory ground for quashing is present. The subpoena demands privileged matter. I cite case law. It imposes undue burden on a non-party. I cite the rule. It violates Nevada's absolute shield law. I cite that. It fails Rule 26B proportionality. It threatens core First Amendment rights. For these reasons, the court should deny transfer under Rule 45F, grant my motion to quash in full, deny Miss Lively's cross motion to compel, and award me costs and fees under Rule 45D. Granting Miss Lively's subpoena would not only contravene Rule 45, Nevada law, and the First Amendment, but it would mark the first time any court in this litigation has compelled compliance from a journalist, an outcome unsupported by law, policy, or fairness. Respectfully submitted, Mario Lavandera, also known as P to the E to the R to the E to the Z, H to the I to the L to the T to the O to the N. Boom, boom, boom. Ah! How do you think I did? Let me know in the comments section. I'm so exhausted, I'm delirious, but I think I did really freaking great. I'm proud of myself. I put it all out there. That's 95% my last word. Now, the Gossip Ghoul alum has 7 to 10 days to respond to me. And then, if in her response there are any lies or misrepresentation, then and only then, which there probably will be lies and misrepresentation, then and only then can I file another final response. But hopefully that doesn't happen. I want to be done with this. I have done all the heavy lifting. I want to be done with this. But I don't want to be done with you. Thank you for watching this crazy long video. Oh my God, if you watched until the end, you are a superstar, A-list human being. Thank you, thank you, thank you. There's so much to discuss. Let's talk about everything in the comments section. Mwah!